You're right.
Yes, Your Honor. May
I
it
bet.
please the court, Felix Martinez on behalf of the appellant Denelli Perez. And I'd like to reserve 5 minutes for rebuttal. In this case, we're appealing the circuit court's ruling that the agreement between the parties is unenforceable as a matter of law. It's a one-page agreement. The record in this case is not particularly large. The lower court based its decision on the four corners of that agreement or that alleged agreement. The lower court held that the document itself is missing essential terms and is not therefore a contract. We believe that that decision was an error. Under Florida law, a contract is enforceable if it contains the essential terms of the agreement. Generally, that's offer, acceptance, consideration, and sufficiently defined terms. The document in this case, which is titled a letter of intent, specifies a purchase price of $145,000. It identifies the parties. It provides a property description by providing the address. It includes financing terms. The financing terms are probably the central issue in this case. There's a $5,000 down payment. There's a $140,000 seller held mortgage, and there's payments of $850 per month, and it's amortized over 30 years.
And
Uh,
Mr. Montanez, can I ask you a question? How do you respond to Apolli's argument that if you look at the letter itself, there is a provision regarding the parties' agreement to renegotiate the payment amount in the future? And so, how do you respond to that?
yes, Your Honor. We believe that that provision, we concede that provision is an agreement to agree, and that provision we believe is not enforceable. But we don't believe that provision goes to the essence of the contract. If there was no agreement in the future, which that provision would not be enforceable, they did not have to agree on anything in the future, then the financing terms that they've already agreed to would control, and those would continue. Those would continue to um, to control the transaction, the mortgage.
So, so basically, you agree that that provision, and so you want us to set aside that provision in that letter and then proceed with the fact that it should be honored. So my next question would be, if that's the case, was that argument made in the court below to basically excise that unenforceable language and proceed with the rest of it?
I Yeah, the record, the lower court record. I don't know if the argument was made in that specific language. The lower court counsel argued that the agreement was in full forcible and that all the essential terms were there. But specifically about that provision, I don't believe it's in the transcript.
Which then leads me to my next question. So how do you respond to Appley's concern that this issue is not preserved for us to review?
I believe it is preserved for appeal because the lower court based its opinion on the four corners of the document and stating that the essential terms are not there. So I believe that issue, whether the essential terms are there, is preserved for appeal. I don't believe the lower court specifically stated that provision would invalidate the entire agreement. That is that provision that really made this contract unenforceable.
Thank you, sir.
Thank you. So I think appellees argue that the document lacks some essential terms. For example, closing costs. We don't believe those are essential terms. The case law, specifically Cohatis v. Russell, specify that those are details that are determinable and are not fundamental to the contract formation. We believe that the interest rate in this case is calculable based on the payment terms outlined in the agreement. We believe it's just a math equation. If you take the sales price, the down payment, and the payment terms, you can calculate the interest. We did so in our reply brief. I believe it's just over 6%. And then as Your Honor was asking, we don't believe that the provision stating buyer and seller to renegotiate payment amount after 5 years, we don't believe that that renders the document, the agreement, unenforceable.
Well,
We
I want to ask you a question. And I think some of this came up in the connection with the motion for rehearing, but the letter has a provision that says that the buyer can pay any additional amount applied to principal at any time with no penalty. And the buyer was trying to do that and had secured or was in the process of securing finance and had asked for a payoff number from the seller. And I think the seller didn't cooperate in that process, so the loan fell through. But doesn't that provision that allows for prepayment at any time indicate that this in fact was a sale and a mortgage and not this agreement to rent that the appellee is trying to characterize it as?
Yes, yes, Your Honor. I believe that that
I mean,
agreement.
we wouldn't get to the 5 years if the seller had cooperated and allowed the payoff.
Yes, Your Honor. I believe that is correct in this case. The transaction is structured like a mortgage. I believe the Florida statute statute 697.01 would make it a mortgage. In this case, it's that provision that Your Honor cited indicates that there's no prepayment penalty, which indicates that it was a loan. It was a sale with seller financing, and that my client had equitable title to the property, even if they didn't have legal title to the property.
Well, I mean, it says on the letter, mortgage to begin April 1, 2016. Maybe that was an April Fool's joke.
Yes, Your Honor, not a very good one, unfortunately.
Not for your client.
Not for my client, yes, Your Honor. So yeah, so we believe all those essential terms which are in the letter of intent are not negated by the fact that the agreement that there's a provision in there that they're going to renegotiate a certain portion of the agreement. We believe taken as a whole, all the essential terms are there, and there was a meeting of the minds. That's all I had. Thank you.
May it please the court. Your Honors, Maya Hatchett on behalf of Kenneth and Marion Strong.
Excuse me.
As stated in my response brief, we respectfully believe that the court properly found that the four corners of the LOI are not enforceable, and therefore respectfully believe that Strong summary judgment should be affirmed. The one-page letter of intent is just that, an agreement to agree. Despite counsel's argument now on appeal that the material terms were in the LOI, it just simply is not the case, and that is what the lower court found.
What language are you relying on to say it's an agreement? An agreement to agree to what?
An agreement to agree as to what the finance terms will be, specifically as to the finance terms.
Well, it says the price is 145. 140,000 is going to be financed. 850 is going to be paid every month for 30 years. And that includes 1/12 of the property taxes and insurance. Paid on the first of the month, late payments, 10% penalty. So is the only thing that you think is an agreement to agree that after 5 years, they can renegotiate the monthly payment?
No, I believe that the material terms include not only that as to the modification or refinance, but also when title will pass, when closing will occur.
Well,
and the interest rate will be.
When does title pass with any mortgage?
It actually passes at the time of the mortgage or before the mortgage, and that's in the case law that I cited. In order for it to be a mortgage, there must be title with the mortgagor, and that's absolute by law. So it
I
absolutely.
want to go back to, I want to go back to the agreement to agree, because I'm not clear on what you think. An agreement to agree to what? Like big picture, what are they agreeing on? As opposed to the terms that you think are missing.
Agreement
Agree
to
to a
agree
sale of the property?
correct, as to when titles to property will be sold and under what terms of financing that
Well,
property.
I think
will
the
be sold.
financing terms are what's laid out in this letter.
And the terms are very clear that only for the interim, there will be payments of $850, and that the parties will renegotiate and refinance terms that will be mutually agreeable between them.
And it allows prepayment, correct? Without penalty.
There is a statement that says there could be prepayment. Yes, Your Honor. And I would say that in the case of CSX Transportation versus Professional Transportation, Inc., there was a similar provision where it came down to paragraph 10D, where it dealt with modification of the agreement. And similar to the case that we have before you, in that because of that requirement of a modification and a requirement of the parties to renegotiate, the court found that it could not be enforced, because there would be terms that the court would have to decide which way they would go on. If there was a breach of that term, there's no provisions that could be enforced. And that
Well, that's another thing that I thought was interesting is I think one of your counts in your complaint was for breach, but you're contending it's not enforceable.
It was pled in the alternative, Your Honor, and what we went forward on summary judgment was on the letter of LOI being unenforceable. And also on
which count was that in? Was that in your declaratory judgment count?
Yes,
I
Your
don't
Honor.
remember which count that claim was in.
Yes, Your Honor, it was the declaratory judgment claim.
Ms. Hatchett, can I ask you about the effect of the sentence in the letter? Seller retains the right of first refusal in the event buyer has an offer to purchase the property. I mean, if this is not a sale with a seller finance, how would the buyer have an offer to purchase the property? Or if the offer, say, I mean, this is at a 145 purchase price. If someone made an offer to the buyer to buy for 200, what would happen?
Well, in this case, I don't think the title to the property had not passed. So if their offer would have been made.
But do you concede? Well, the other side would argue there's at least an equitable interest here, correct? Or not?
I believe that there's anticipatory interest, Your Honor, in that once the parties renegotiated and came up with financing terms, there would probably be title had to pass in order for there to be an effective right of first refusal.
Okay, so what happens? So in the meantime, I mean, this doesn't seem to be qualified. Seller retains the right of first refusal in the event the buyer has an offer to purchase the property. If title hasn't passed, what is the effect of that sentence in the letter?
If the buyer receives an offer to purchase, then the seller could make an offer to purchase the property back at that same amount.
Even though title has not passed?
I think that is exactly
or
why.
Even though or perhaps because there's at least an equitable interest in the buyer.
Perhaps, Your Honor, yes, there would have to be an equitable interest, but I think that provision also shows this is an agreement to agree. And I go back to CSX Transportation, where the court found, if there is this specifically found that terms which bind the parties to some end result is left open. Because an essential term of the agreement was left open, the court could not fashion a remedy in the event it determined either party breached this provision of the agreement. It's a perfect example of this being an agreement to agree. The terms were left open.
Well, let me ask you about, I want to go back to what I was asking appellant's counsel about. The buyers attempted to prepay, and they asked, we would never even get to the 5 years. They were trying to prepay payoff amount, and the seller wouldn't cooperate. It could have been paid off. What's your response to that?
Your Honor, those facts are not in record of the trial court. Those are
well, they are in the record. That's where I got them. They weren't argued at the summary judgment hearing, but it came up in connection with the motion for rehearing, so it is in the record.
They were in the record for the rehearing, Your Honor. They were not in the record for the trial court's decision. And they were created.
But nevertheless, it's in the record.
They were, well, if we had the opportunity to the extent that they exist, it would have been presented for summary judgment. They didn't exist. After the fact that summary judgment was entered, did Ms. Perez approach us as to trying to refinance? Yes, but that was for purposes after summary judgment was entered. It was not for purposes of trying to save the property prior to summary judgment. Those are all facts that were introduced after summary judgment being entered. They were never raised as affirmative defenses. They were never raised as summary judgment. And that is why my response also goes into the argument that these issues before the court now, and even the facts that are trying to be introduced, are not in the record for the summary judgment and are improper in regards to this appeal. I would state, Your Honor, just to summarize, I believe that that it is very clear from the record that the letter of intent is unenforceable from the plain reading of the document. As I've stated, it essentially lacks finance terms. By leaving open the provision of the refinance, that is an absolute essential term that had to be written out. As to the term about the right of first refusal, that is another term that cannot, because it was left open-ended, it cannot be enforced. The fact there was no interest rate stated, the fact that there was no closing date in the document, it doesn't also state how.
Wait a minute, hang on. Why do you need an interest rate stated if it tells you what the monthly payment is?
It's a
Who
temporary.
cares what the interest rate is?
Because it's a temporary interest rate. As the document expressly states, the parties will there will be a refinance and a new rate will be decided on.
Well, it doesn't say that exactly, but what difference does it make then? What difference does it make? I'm sorry. You've lost me on why some of these things are material.
The fact that
why they're material
as to
when they know the total purchase price, they know the down payment, they know the monthly payment, they know that includes taxes and as insurance, they know the term of the loan, 30 years, they know the date of payment, they know the penalty for a late payment, they know where to send the payment. So the fact that it doesn't specify the interest rate, but it does specify the payment of the price, which is amortized over 30 years. How is it material? Why do we need to know the interest rate?
Because
you've lost me on that part.
The refinance terms are found to be a material portion of a contract, and that's found not only in CSX Transportation, but also in Glosser versus Vasquez, which I cite in my response, where the refinance.
So your problem is with that one sentence that says after 5 years, the parties can agree on a new monthly payment. That's really your problem with this agreement.
No, I believe that is only one of the essential terms missing. As stated in my response briefs, there are multiple missing terms, including what title and when title will transfer to the property. Without that actually occurring, and without that being delineated in the agreement, that is a material term that is open-ended and cannot be enforced. As I stated, that again, just the arguments raised by counsel in regards to the appeal are not proper because they have not been raised on the trial court. And I cite to the cases of Sunset Harbor Condominium versus Robinson for that premise. But going past the LOI not being enforceable, the idea of the mortgage, this cannot be a mortgage. And I've already stated on the record today, in order for it to be a mortgage, and all the cases cited by counsel, title had to have passed to the appellant. In this case, it's undisputed.
How do you account for the language that says mortgage to begin on April 1, 2016? And I understand your argument that as a matter of law, it cannot be a mortgage. But apparently these parties thought it was. That's what they called it. What do you make of that? Does that have any significance?
It's not enforceable because there is no title passing. There was an intent that there would be a mortgage in place and that it would be the interim terms were stated in the LOI, and then there would be refinance terms agreed to by the parties for the remainder of the 30-year amortization. But because of that agreement to agree, it cannot be a mortgage and it cannot be an enforceable contract. Finally, Your Honors, I would just address the argument of partial performance. It cannot be partial performance here. One, because we don't have an enforceable agreement, but two, the issue only of partial performance comes up on an issue of statute of frauds. And here, there is no time. Was the statute of frauds argument ever made, or was that a decision of the trial court? And therefore, partial performance is not a proper consideration here, and also was not raised on the trial court level.
Are you finished, Ms. Hatchett?
Yes, Your Honor.
Okay, thank you. Okay, Mr. Martinez, you're up.
Yes, just briefly, I would just cite, we cited in our materials to Florida Statute 697.01. It says all conveyances, obligations, conditioned or defeasible bills of sale or other instruments of writing, conveying or selling property, either real or personal, for the purpose or with the intention of securing payment of money, whether such instrument be from the debtor to the creditor or from debtor to some third person in trust for the creditor, shall be deemed and held mortgages and shall be subject to the same rules of foreclosure and to the same regulations, restraints, and forms as are prescribed in relation to mortgages. I just cite that because—
Well, I'm sorry to interrupt, but I want to get this in before your time is up. I don't recall reading that argument in that was being made to the trial court. I don't recall that was made to the trial court. What I recall the argument being is challenging the affidavit as not competent evidence to support the summary judgment.
Yes, the oral argument focused primarily on what competent evidence was established and what material terms.
Are you suggesting the written response made this argument about it was a mortgage?
I don't believe that statute was specifically cited anywhere in the record.
Okay.
I just believe that. So I believe appellees are arguing that title has to pass in order for—
Well, I mean, the issue on the summary judgment was this is an unenforceable agreement.
Yes, so I believe the lower court based its decision on the four corners of that document and decided that as a matter of law it was unenforceable. So I believe Ms. Hatchett is correct that the statute of frauds is not an issue in this case. We probably shouldn't have cited to it in our brief. I apologize for that. Thank you.
No, it's all right. I just want to make sure I didn't miss it.
Yes, Your Honor. Yes, Your Honor. Yep, that's all I had. Thank you very much.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to look on the lower right-hand corner of your Zoom screen, and there will be a button there that either says leave or is a graphic of a person